The lead defense lawyer for Yebu Zainab Sheriff, Olan Wright, made a no-case submission on the grounds that both count 1, which is incitement, and count 2, which is threatening language, did not amount to valid charges and therefore should be totally disregarded. He said count 1 was invalid both for form and for sanctity. He submitted that incitement by itself was vague and incomplete, stating that incitement should be backed up with a stated offense, as in incitement to commit murder. He said the count was also uncertain because it was not indicated in the face of the charge which election was rigged and by whom. He added that count 1 was also a nullity because it failed to indicate those who were incited. Defense lawyer Wright said count 2, which is use of threatening language, was also vague because it did not indicate the person to whom the language was directed. Defense lawyer Wright said count 2, which is use of threatening language, was also vague because it did not indicate the person to whom the language was directed. He added that the defendant equated the rigging of elections as tantamount to treason, which was constitutional, and treason was subject to a death penalty. He said the defendant's statement was a deterrent to electoral malpractice. However, he said the defendant's suggestion was a constitutional impossibility when she said, "Dem for do am like how dem do for the Sanko." He emphasized that even if somebody incites, but he knows that such incitement is impossible, it was not incitement at all. While responding to the defense, State Prosecutor Yusuf Isaac Sise held a contrary view that the counts were nullity because the charge were incomplete, referring to the Criminal Procedure Act of 2024 and a judge-made law that states a defective charge should be cured so long as an offense known in law is disclosed in a charge, and on that note, incitement is known in law. He also opposed the defendant's submission that incitement had to be directed to a person or persons. He said incitement was made even though it was not directed to a specific individual but to the public. He disagreed that if inciting someone on something impossible, it was not incitement. He said a person could be held for incitement even if it was impossible. He added that the purpose of the law would have been defeated if that was the case. He said the death penalty in the country had been abolished and it was not part of democracy to kill people because of allegations of rigging elections. Therefore, the defense's no-case submission had no merit. He added that by the defendant's body language, she was very intentional. Having heard the submissions of both the prosecution and the defense, Magistrate Baima Jah denied the defendant Yebu Zainab Sheriff bail and adjourned the matter for ruling on 31st March 2026. For SLBC, Mohamed Kouma reporting.